Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome everybody to the show. Today we are talking to Kevin Sayles, who's a vice president at Lawyers Titles. Now let me tell you something. If you are in the world of probate in Los Angeles, sooner or later, you're going to hear the name Kevin Sayles. Kevin, welcome to the show.
Thank you for having me. I'm so glad to be here.
It's a pleasure to have you. And you are such a wealth of knowledge. We've had the opportunity to talk. And so let's delve right into it. Let's first start by what you do. You work for a title company. What is a title company?
Title company is part of the closing services. A lot of people know, well, when they're buying a house, oh, I entered escrow or I opened escrow. Right. Title goes right along with escrow. It's kind of like title and escrow together. In fact, in other states, title and escrow are together. They're not separate. Right. But here in California, the title company, what we do is we do a report that gives the ownership rights and interests that go along with the house. And so we produce that. It's called a preliminary title report. It gets sent out usually a few days after, maybe a week after escrow is opened. And it's something for a buyer to look at and understand what they're getting with this property.
Now, in the world of probate, sometimes the preliminary title report is made available prior to submitting an offer, and we will get into that in a little bit. So what does a title insurance company? So the question comes to say, what is title insurance?
That's a very good question. So we insure the transfer from the seller to the buyer. So, you know, especially for Southern California, a lot of times the buyer never meets the seller. The buyer may only know the seller's name from seeing it on the contract. They don't actually ever meet them in person. And so we do a few things. Number one, if your seller's name is John Doe, there could be 50 John Does in Los Angeles. There could be a whole bunch of them. How do we know it's the right John Doe? So we're responsible for some of those things to make sure that our seller is the proper owner of the property. They're not an imposter. You know, nowadays with fraud, there's people that impersonate people and stuff like that. So we kind of take on some of that liability with our insurance policy to ensure that the property goes from the seller to the buyer. And so that buyer has that property with another thing that we do with all the seller's liens and the seller's judgments, if they have any, or the seller's loans, anything that was the seller's being cleared from the property before it goes over into the buyer's name.
Very nice. Very good. Thank you for that. Now, you brought up an interesting point. You said John Doe is the owner of the property. Now, in probate, sometimes John Doe has passed away. Yeah. So what is the difference when somebody comes to you and says, look, Kevin, you know, we're selling this property and it's going through probate? What are some of the things that differ between the two transactions when the seller is living rather than when the seller has passed away?
Very good question. And that's kind of the start of everything. So when the seller is living, title to the property, meaning the deed that shows who owns it, will say John Doe is the owner.
Right.
When John Doe is deceased, it makes for a different transaction, right? So if you're buying a property from John Doe and he's alive, then we know John Doe's the seller. He's the person that should be signing. We make sure that they are who they say they are, and that's the person that's selling the property to you. But when John Doe is deceased, then there are court documents that put someone in charge of that estate. In California, when someone dies owning their property, it goes through probate, and the probate will appoint someone to be in charge. There's a court order that comes out that says this person is in charge of John Doe's estate. And that's how we know who will be signing the deed, which is the transfer document, over to the buyer.
Great. So because this is a question that we often get on the sales side, on the when people are approaching us as the buyer's agent, they're always saying, you know, like who's signing the deed and all of that if the person has deceased, if they never purchased probate. So this is a good example with probate. We'd say probate court will appoint somebody to be in charge of selling the home. In the case of a trust, tell us about the difference, because if the property is being in a trust, you will see on the vesting, which is the name that it's on title, you will see trustee. Now, how do you approach that differently when somebody tells you, you know, the trustee is deceased, that it's the name on title? What is your step now?
Yeah, it's totally different. When there's a probate or when someone dies with their name in their individual name, just their name, John Doe, we can't do anything until we get that court order from the court that
Right.
says, it's called letters. It's the letters that put so-and-so in charge of John Doe's estate. We can't do anything till that happens. That's kind of like the first step.
Right.
When it's a trust, it's different. So in a trust, a person takes the property out of their individual name and puts it in their name as trustee of their trust, or whoever their trustee is going to be. It could be a different person or something. They put it in the name of the trustee of the trust. So when there's a trust and that person passed away, we have to see a copy of that trust. So the family, the seller, the successor trustee, whoever it may be, will provide a copy of that trust, and that trust will let us know, okay, this is the person that's in charge when the original trustor or the original person passes away.
Very good. Now, we'll get back to some of this in a little bit, but let me ask you a question about title insurance. Essentially, you said that, the title insurance does, we make sure that the transfer is legitimate. We vet, all the people that are involved to make sure that everything is properly done. What happens when something is not done? So what is title insurance there for when a claim is filed?
Yeah, so we provide an actual insurance policy. So let's say at the end of the day, the policy says Jane Smith is our new owner. She's the buyer in the transaction. And so we do our insurance policy, and the policy said Jane Smith was going to be the owner, and that there's only one loan, the loan that she got from ABC Bank.
Right.
That's the way our policy would close based on what the lender and the buyer require for us to insure them on. So later, let's say that later the seller's loan didn't get completely paid off. Or the seller's lender, one of the seller's creditors, comes back and says, oh, you owe us some additional funds.
Right.
Those things would fall on the title company. The buyer, Jane Smith, I believe I said her name was Jane Smith, would then file a claim with the title company for us to make sure that gets cleared and taken care of. Right. If it's a lawsuit or a legal issue or someone sues based on the previous ownership, the title company typically will step in and fight that lawsuit or get the lawyers to defend that situation based on what went on and what we insured.
Very nice. Great. Let's get back. Let's take it a step a little back. So let's get back into our imaginary escrow, if you will. And we have the letters have been received, which are appointing an administrator or an executor. Would you like to tell our audience the difference between a personal, they're both personal representative, but between an administrator or an executor?
Sure, absolutely. I'll tell you what I know. And just to, make sure it's clear on the record, I'm not an attorney. I work for a title insurance company. I close real estate transactions. But a lot of the questions, that you may have could go to an attorney. But so typically an administrator is appointed by the court, whereas an executor is designated in a will. So if there's a will and the will says, oh, when I die, I want little Johnny to be my, executor of my estate, then they would be called the executor. If there's no will, or maybe there's some problem with the will, or the will doesn't designate a person, then they would be called the administrator because they're appointed by the court. Either way, their role is pretty much the same. So it doesn't really matter whether they're an executor or administrator. For our purposes on a real estate sale, they're the same.
Yes, perfect. Now, as far as the sales price is concerned, there are some elements that are involved in a probate transaction which are not involved in a regular transaction. So my question to you, Kevin, is what is preventing, even though thankfully the court is involved to make sure that the estate gets the most money. Essentially, that's what the probate code is there for, to protect the deceased and the deceased estate. What is preventing a person from, selling their home for $5 to their cousin? What things are there in place to help with that?
Well, I'll tell you from my personal experience being an administrator of an estate, there's documents that you get sent from the court that basically tell you what your duties and liabilities are, and that you could have some personal responsibility. If I don't do the right things, if I don't, it doesn't mean I have to be an expert in real estate, but if the agent is telling me the house is worth, $500,000, if I don't sell it for that, I could be damaging someone's inheritance. And if I do something wrong or illegal or something like that, I could take on personal responsibility. So when it comes to probate cases, if it's a full authority case, pretty much they sell the property and they report it to the court later, what they did. But if it's limited authority, I've seen judges reject sales if they were not a percentage of what the court referee, which is kind of like an appraiser, what the court referee says the property was valued at.
Very good. I'm glad you brought up the probate referee in this particular case, because kind of like that's where I was going with this, in the sense that obviously I wanted to kind of make a side note here. This is how important it is for the audience that's listening. When you are a personal representative, when you are dealing with a state, it's so crucial to surround yourself with people who are familiar with this process. I often happen to be the second or third agent that ends up working with somebody because people don't get the information up front, and they're like, you know what, hey, this guy took a little course, they're certified. Unfortunately, there's a lot of nuances to work. So one of the nuances that there are to keep in mind and that we're going to discuss, and obviously we're not attorneys, but we are involved in the sale of real estate through trust and probate. So we get to see these things all the time. We always encourage somebody who comes to me, unless this is my case, somebody who comes to me and says, I filed my own probate, can you help me? Seek legal counsel is always, the best practice. There are some notices involved, Kevin. It's called a notice of proposed action. Like I said, we're not attorneys, but we see these all the time. Why is it important for you who are providing title insurance to receive information of the notice of proposed action, for instance?
Yeah, that's a good question. So the probate code requires it. I'll give you an example. I had a person who was selling a property and they have full authority. And apparently one of the heirs, when I told the agent that, yeah, we require the notice of proposed action, one of the heirs got a phone call. I'm sorry, one of the heirs called the agent and was going on, he has full authority. There's no way he has the right to do whatever he wants. He can sell this property. And so they called me and said, well, Kevin, why is your title company requesting this? I said, well, it's not so much that we request it, it's required in the probate code. Because it's required in the probate code, we just want to see that it was done. And that calmed all their issues. They didn't really understand that the probate code requires this notice. The notice of proposed action is a notice that goes out to all the heirs, letting them know the transaction that's being contemplated. And so we have to see, as a title company, title and escrow company, part of the closing process, we have to see that document to know that the proper notifications were done in the case, so that we know we're clear to close the transaction.
Very nice. Very good. Yes. And this, by the same token, our audience should be aware of something called, there are publishing requirements prior to the acceptance of an offer. And this is why it's so important to have people in your corner that know what they're doing, because I have seen these personally before, go to court with an accepted offer that gets rejected because there was no record of any publishing done about, so the process, there's a big difference between a notice of proposed action and the publishing. The publishing is more aimed toward the creditors and the public at large, that this action is taking place. So because it's so complex, Kevin, because there is so much to go, and only through experience you get where you are. When somebody is in the middle of a transaction and they are in need of kind of like checking all these boxes, hopefully they've already surrounded themselves with people like that. How did you fall into this world? This isn't like just everybody's like, oh, when I'm a little kid, I'm dreaming that I'm going to be, I'm going to be an expert in probate sales.
Yeah, that's very true. It didn't happen like that at all. The way I got involved and got experience in probate is back in the 90s, I was a manager at a bank,
Okay.
and the bank branch that I managed was burned down during the 1992 riots.
Okay.
So here I come in, the manager in 1995. And at that time, banks, we would keep actual original or certified copies of court orders for certain transactions that needed to be done. So you wanted to come in, withdraw money from a conservatorship account, et cetera. We would have the original documents in our branch. Well, imagine how fun it was for us when someone would come in to do a transaction and we would tell them, oh, your documents were burned in the fire and we can't do your transaction. So, I ended up having to go to the courthouse in downtown LA frequently to rebuild files, to rebuild cases. You can get the most of these court cases are public record documents, so you can get new certified copies so that we could transact on these accounts. So that was my first introduction to it. Also at the bank, you had to know certain things about the probate code in terms of, it's because if someone died, could you let them in the safe deposit box, or what could you tell them about their account? So we had to know that stuff as bank managers. And when I got to the title company in 1999, I didn't realize how much I knew until I started working on this side of the business in title insurance. And then I realized, oh wow, I have a lot of knowledge here. So when you have knowledge about something, you tend to get more, you attract more and more of it. And over time, I just started doing more and more probate transactions and meeting attorneys and all that kind of stuff. So it just grew from there.
Very nice. Now, because your name is kind of synonym with the probate world in Los Angeles, at least I feel that way. My team has been in the business a very long time, and even before you and I met, I knew who you were. Because of that exposure that you have, do you ever have somebody reach out to you who may be a seller themselves and be like, hey, I need help with this, what do I do? And what do you do in those cases when people reach out directly to you?
Periodically, not a lot of that. More what happens is real estate agents or real estate professionals hear about me or know about me, and they end up calling. Or maybe someone is in an office and they're like, I'm struggling with this situation, and a friend of theirs may know who I am, and they'll say, oh, you should call Kevin Sayles. I don't get that often where the individuals do, but from time to time it does happen. And I help them just the same way, especially because sometimes they maybe they don't know what direction to go in, or sometimes they've watched a YouTube video, but it's a YouTube video under Texas law, not California law. So they're thinking about it the wrong way. So I typically try to steer them in the right direction. I had one last week that a person called me, and it was funny because she didn't want to give me a property address and everything because she said her husband had told her that people will try to take the deal from you. I said, well, I'm not here to take anything from you, but I can't really answer some of your questions as I see what went on with the property beforehand. So I try to help them the best I can. Sometimes they don't trust me or maybe they don't believe me, but I give it to them as straight as I can, whenever possible.
Yeah. It happens to me as well. I think I had mentioned this before. I get calls from agents on a regular basis, from agents all over California that Google me and find me, as the probate realtor, and are asking me questions. And I'm always glad to help, and I'm always glad to give them the directions. But some of the questions that you hear are very bizarre indeed, bizarre indeed. Okay. We have only scratched the surface, but I'm trying to keep these episodes to a certain length. So I am going to have you back if you are okay with this, because it's been such a pleasure to have you on the show. But before I let you go, you're not off the hook yet, because every episode has to end a specific way. So I have a list of 30 questions, and they're numbered 1 through 30. And I just want you to pick a number, any random number. And this is kind of like the back of the card type of question. So let's let me know, pick a number between 1 and 30, and I'll ask you the question.
Let's go 15.
15, okay. If you could have one superpower, what would it be?
And the only reason I know the answer to this question is because me and my kids have asked this when we're watching the Avengers or a movie. I think mine would be teleportation.
Oh, okay. All right. Why?
I deal with the LA traffic all the time. I love to just go, and I'm there,
Very good. This answer is very appropriate to an Angelino. Now, pick another number.
Let's do 24.
What is your favorite excuse to get out of something?
I typically don't give a lot of excuses to get out of stuff. I give real answers. Like if there's a real reason that I can't do it, I state that real reason. So I won't say my favorite excuse. I'll say a common excuse. Someone was just calling me earlier today. We were trying to schedule a meeting, and it's a common excuse is that I have appointments. I set a lot of appointments, and I treat my appointments like a doctor's appointment. I wouldn't cancel one just because something else comes along. So, so usually I'm tied up, or I'm busy, or I have another appointment at that time. I don't say that's my favorite, but that is probably my most common.
I love that. Spoken like a true gentleman. Like I love that, because as I'm doing this show, I'm learning how people are running their businesses as well. And you say it's very true. You treat every appointment like a doctor's appointment. Like, just because somebody calls me and says, oh, I need this now. It's like, well, I'll get to it. And that's very important. It's very respectful to all the clients. It's been great. Before I let you go, we are going to have your contact information in our show description of lawyers' titles and how people can get a hold of you. Is there a good email or phone number you'd like to share with our audience to get a hold of you?
Yeah. You want me to just say it right now, or?
Yeah.
Okay.
Yes.
My email is Kevin, Kevin, my last name Sayles, Sayles, at LTIC.com. That's short for Lawyers Title Insurance Company, LTIC.com.
Perfect. Kevin, it's been such a pleasure to have you. Thank you so much. Thanks to our audience for joining us. It's been a wealth of information. We've only scratched the surface. We're going to have Kevin back because he's like a rock star. So we need to have an encore. Thank you, everybody, for joining us. And we'll see you on the next episode. Bye. Say bye, Kevin.
Bye-bye. Bye, everybody.